So I'm going to be talking about the use of statistics in the law. So this is a topic that I guess I've been thinking about for around, since around January. But a lot of the things I'm going to say today I've only been thinking about for around 3.5 weeks. So hopefully you can help me with what is really a work in progress. Even if I've not sort of solved the issues I'm going to present, I think it raises some sort of deep fundamental questions in philosophy that often get neglected, and they've also got a lot of important practical ramification. So I guess we'll go a lot of backgrounds here. So a brief sort of recap of the last sort of 40 years of epistemology. So the sort of caricature goes, philosophers who work in epistemology have moved away from analysing states-like knowledge, trying to find necessary and sufficient conditions, towards research questions that have more social implications. So people have been asking, what's the role of epistemic states-like knowledge? What does knowledge do? So for example, does it have a particular role in licensing when we should assert things or when we should act upon pieces of information? Social epistemology has been a big growth area in the last 20 years, looking at questions like when do collectives and institutions have knowledge? And equally, there's been a big growth of questions looking at the moral dimensions of different epistemic states. So, do moral factors influence when we attribute knowledge to people? How do sort of social injustices preclude certain people from being attributed knowledge? Questions like this. So naturally, the upshot of this is there's been a lot of work in legal epistemology, because this sort of ties together some of the big trends that we find in the last few decades of epistemic research. Looking at the role of knowledge, what does it do, looking at when certain collectives, such as courts, have knowledge, and obviously questions of law have lots of ethical ramifications as well. So there's been a huge amount of work in legal epistemology. So a lot of this work in legal epistemology has been concerned with the role of statistics in the law. And you might ask, well, why is this? So I think there's a few different explanations. There's a sort of structural explanation, one being that, well, epistemologists have been concerned with statistics for ages, and one of the biggest areas in epistemic research concerns sort of the lottery paradox and how we should treat lotteries as a source of evidence for certain propositions. People have thought for a long time that, for example, statistics are somehow different from other sorts of evidence. That we shouldn't attribute knowledge on the basis of mere statistics of an outright proposition. So say you've got a really large lottery, you might think, even though it's really likely, you don't know that you've lost. In fact, that's the sort of motto of the New York State Lottery is, hey, after all, you never know. And there's also a sociological explanation for why epistemologists have been so interested in statistics, I think. And part of this is a sociological one, which is they have a lot of theories they've developed about lotteries on the shelf, ready to ship, to talk about analogous legal problems. And if there's one thing philosophers like, it's taking theories they've developed elsewhere and applying them to new areas without too much extra work. So I think there's these two. Yeah. So I think these two factors explain why legal epistemologists have been so interested in talking about statistics in the law. So I'm going to give you an example of what's called a proof paradoxical case, and this has been what most of the literature has focused on. So, imagine we have two buses. So imagine there's been some sort of accident, and in the locale in which the accidents occurred, there are only two bus companies operating, the red bus company and the blue bus company. And let's suppose that for some reason we know that there's been some harm caused negligently through dangerous driving, but we don't know which bus, which company the bus belongs to. You might imagine we've got a colourblind eyewitness or something like this. So the only evidence we have to determine who owns the bus and who should be found sort of liable in civil law is statistical analysis of how often buses of a certain type are on that road. So you might suppose that, well, let's say 65% of the buses belong to the blue bus company and only 35% belong to the red, and this is the only evidence we have to distinguish between them. This is what's called a proof paradoxical case. So the reason it's proof paradoxical is that, well, the only evidence available is statistical, but there's an intuitive reluctance to find either party guilty in that case. There's a sort of widespread thought that maybe some of you share, and that we shouldn't find a particular party at fault just on the basis of mere statistics. These cases also appear in sort of criminal domains as well, so often they're very artificial. So you might imagine that, well, this is a silly case, but it's the one that comes to mind. There's some sort of civil unrest going on, and 100 televisions were removed from a shop. The cash register shows that only one was legitimately purchased, while the other 9 were carried away. They stop someone with a television and they say, hey, you stole that television. Well, the defence is, well, no, I'm actually the one that bought it legitimately. And in this case, there's a 1 in 100 chance he's telling the truth, but many people have thought mere statistics are not a sound basis on which to found a criminal conviction. So, this should be puzzling in some ways, because it seems that statistics can at least be as truth conducive as other sorts of evidence that we like routinely. So we often rely on eyewitness testimony, and there's a sort of huge body of psychological evidence where the eyewitnesses go wrong reliably, especially in high stress situations. So it seems that as long as you make the statistics large enough, it seems that that should equal our faith in that sort of source of evidence just as much as, say, eyewitness testimony. But it also seems to sort of undermine our understanding of what the idea of legal proof is. So in civil cases, like in the bus case, the standard of proof that the court uses is what's called the balance of probabilities. And the most natural way to understand this is just more likely than not. So if you go to court with a contractual dispute or some sort of tort-based dispute, the standard that you have to prove your case on is the balance of probabilities. And you might think it almost seems true sort of by definition that the blue bus company is more likely to be at fault on the balance of probabilities. It seems like you've almost baked that into the case. So if you think this is true, but you're also sort of reluctant to sanction them, then it seems there's this tension at the heart of how we understand what legal proof even is. It's hard to make this out with the criminal case, the criminal standard of proof, which is beyond a reasonable doubt, because you might think, well, if there's only statistics at play, we've always got a reasonable doubt. But then again, you can make the statistics extremely high, involving sort of very, very tiny chances of error, and then compare that to eyewitness testimony on which we often base criminal convictions. And it seems, well, why is a reasonable doubt not? Why is it not reasonable to have a doubt when you're believing a compelling eyewitness, but compared to the statistical case? It seems like there's some sort of tension there in our understanding of what proof requires. So, there's been a sort of orthodox response to these cases among epistemologists who have thought about the proof paradox. And this is, well, we're going to accept the intuition that it's never right to sanction a party just on the basis of bare statistics. And we're going to explain this by appealing to the absence of some sort of epistemic status. So the idea is that, well, you can't know someone is guilty or be justified in a certain way in believing that they're guilty just by relying on statistics alone. So the idea might be, well, you can't know that the blue bus company caused the negligent harm just by relying on statistics. And this is a sort of unique feature of statistical evidence, that there's certain cases in which it doesn't yield knowledge. So it's safe to say that this has been a fairly popular response in recent years, with all of these figures endorsing some version of this idea, the idea that we should never sanction on the basis of stats, and the reason for this is because there's some epistemic deficit there. So, the natural challenge is, well, look, why should the court care about particular epistemic properties like knowledge? Because by hypothesis, you might think, if we don't rely on statistics, what that requires us to do is to make sort of accuracy sacrifices. If we're not going to rely on statistics, even when they seem to be very truth conducive, this might actually seem to lead to a less accurate court system than we might otherwise have. So why should we be so concerned with knowledge, for example? Seems like a natural challenge to raise. And it seems like a very appealing response. A very appealing response is that there are sort of justice-based constraints on legal verdicts that somehow align with these epistemic properties. So this is maybe easiest to see in the criminal case. You might think there are certain accuracies not all we care about. I mean, there's this very dominant thought that it's worse to, we prefer to sort of let guilty people go if this preserves false convictions of the innocent, rather than the other way around. So you might think there's sort of justice-based constraints on how we make decisions in the law, and some people have thought that, well, knowledge is what's important here. So you might think, if you're relying on bare statistics, there's a sense in which we could very easily have been wrong. And people often cash this out in sort of modal terms, and there's a sort of nearby scenario in which we could have been wrong if we rely on statistics. Think about the bus case. I mean, it would be quite normal for us to be wrong in the bus case, but there'd be nothing sort of funny going on if we happened to be in the scenario in which the bus belonged to the red company and not the blue. And people often think that this sort of modal robustness is what characterises knowledge. So safety views are a big family of view when we think about what knowledge is. People think that sort of knowledge is modally robust. So a very natural thought as well. Knowledge is sort of removes the sense of the possibility of easily being wrong. And this is the sort of the story that a lot of epistemologists have told when they try to explain why these epistemic statuses are so important when it comes to the law. Because they align with these justice-based constraints in how we make decisions. So elsewhere in my work, I've looked at this problem from the perspective of the civil law, and I've sort of explained how, well, things seem to be somewhat double-edged because the orthodox approach requires excluding certain uses of DNA evidence. Because it might surprise some people to know when courts consider DNA, all they consider is a probabilistic estimate of how likely it is that samples match. Because sometimes samples match for purely, there can be just accidental matches. You get what are called random matches. So if you've got a case in which your DNA is on file for some reason unrelated to a crime that's occurred, and then they sort of sample the DNA from a knife or something like this, there's like a 1 in sort of 10 million chance that you could just accidentally match with that DNA sample. So this is a bit like, this is a case involving purely statistical evidence, as long as we suppose there's no other incriminating evidence at play. And it seems a little bit like a lottery, right? But unfortunately in this case, the sort of winning ticket gets you a life sentence. Right? So there's like a 1 in 10 million chance that you can be falsely sort of accused of a crime on the basis of an accidental match. But you might think that, well, there's actually a whole bunch of cases, especially in sexual crimes, where there's often a positive evidence that we actually want to accept this trade-off. We want to say, well, we use DNA evidence to solve historic sexual crimes. Often when there's no other evidence to go on, you might think this is a fair enough match. We might not know they're guilty because there's a sense in which we could easily have been wrong if there was just a random match going on. But you might think that there's justice-based considerations that might make us want to rethink including this evidence. So today what I want to do is focus on the civil law. So sorts of cases involving torts, and if people don't know what that term means, I guess tort cases are cases in which someone has suffered a harm that's been sort of negligently imposed on them by another, but it's not criminal, you don't have a criminal mental state. So classic cases are like, well, you own a shop and you affix a sign to the door and the sign falls down and hits you in the head. That's a sort of tort case. You're not a criminal for doing that, but you have been negligent. And this is probably the biggest area of civil law, and in fact takes up much of the court's business. So what I want to do is think about how statistics might be required to serve, using statistics might be required to serve certain public policy objectives. My job title is Fellow of Philosophy and Public Policy, so I want to use the phrase public policy as much as possible and think about how statistics might serve these objectives, particularly in distributing risks fairly across society. And in the back of my mind, I want to be concerned with this sort of sociological fact that I observed about using sort of off-the-shelf epistemic solutions to make prescriptions about what are actually really practically important questions. I mean, I think if we did, as these epistemologists recommend, this would have some quite adverse effects across the legal system. So that's the sort of big picture. So, a quick aside, philosophers are often a little bit sloppy when they talk about what legal proof requires. They often talk about as if when you prove a case, you're proving like one great big proposition on a standard of proof, but actually it's a bit more complicated. So usually what you have to prove is you have to prove a number of distinct propositions, each on the standard of proof governing the case. So if you want to prove a civil case, you have to prove that there's been harm, you have to prove that there's a duty of care that's been breached, and you have to prove the causal connection between the activity and the harm. You've got to prove each of these things on the relevant standard of proof. It's not like you just have to prove one big proposition, like he did it, you know. You've actually got to prove these distinct strands, each on the standard of proof. So philosophers are sometimes a bit sloppy in this. So, does anyone know what that is? No. So this is asbestos. So, going to move now to talk about some sort of practical legal developments. So we've been doing some case law lately, and I think thinking about these practical developments can help us get a grip on the importance of using statistics. Because often what judges do when they write cases is they engage in a sort of pseudo-philosophy, and often some of it's quite good, some of it's terrible. But if you read these cases, you can actually see sort of from the ground up, they're constructing these edifices that explain why statistics are actually pretty poor. So asbestos exposure, especially in the UK, is a big problem. It's been banned now for decades, but only now is the diseases from asbestos exposure beginning to spike, and particularly afflicting working class men who have been working in the shipyards, etc., but also their partners, because asbestos dust is so dangerous that even, I guess back in the 60s, when gender roles were more traditional, women who were cleaning their husband's work clothes were inhaling asbestos dust, and they're getting diseases such as mesothelioma that are often fatal. So the numbers of people dying from these diseases is spiking in the last sort of 5 years, and that's going to continue to be the case for the foreseeable future. But of course, tracing a causal link between sort of any episode of asbestos exposure and mesothelioma is very different. So if you consider the average career of a working class shipbuilder, they're often going to be working for many different employers, 5 or 6, often they're on short-term contracts, moving from shipyard to shipyard, working in different parts of the shipyard over a period of sort of 30, 40 years, the sort of span of someone's working life. So it's very hard for them to identify any particular employer and say, well, it was when I was working for you that I contracted this sort of proto-symptoms of mesothelioma. So it's really hard for them. People that are sort of dying from these diseases find it very hard to trace a causal link between any particular employer and sort of get compensation for this. And this is multiple parties involved. So what the solution has been in the law, and this is something that's been very controversial over the last 10 years, and there's still sort of appeal cases going to the courts challenging this, is to sort of relax the requirement to prove causation. So the thought is, with the information we've got now, you can't sort of prove simpliciter that any particular party caused the damage, caused the disease, but what they do is they rely on statistical evidence about epidemiology, about sort of disease frequency given assumptions about the danger of exposure, and this can be used to sort of pin liability on given employers. So the courts admitted that, well, these statistics can't prove a causal link, so in that sense they're sort of agreeing with what the epistemologists have said about statistics, but what they're saying now is that, well, in fact there's important reasons to sort of think that we need to do something about this fact. What we need to do is relax the usual requirements of causation, we need to sort of change evidence law in these cases. So the second case is the use of drugs that turn out to be harmful. So a commonplace fact about life, the medical system often prescribes drugs that we seem to think are very helpful, or they are very helpful in some respect, but only becomes evident decades later that they, for example, have a carcinogenic effect. So unfortunately, a lot of the high-profile examples involve pregnant women, so I'm thinking about thalidomide and this sort of drug DES. I think thalidomide was for morning sickness, was that right? Or, yeah. So this is sort of, it's not a common occurrence, but it's not unheard of either. And the harms are often severe, so it can often lead to sort of disabilities in children if it's for pregnant women, or it can even just lead to sort of carcinogenic effects in people who are ingesting these drugs. But obviously, if you've been ingesting a drug sort of 20 years earlier, it's often very hard to work out who manufactured a given drug. After all, you've consumed it, presumably you don't keep the packets of every drug you've consumed. And in the pharmaceutical industry, depends on the nature of the drug, sometimes there's multiple different manufacturers making the drug. So it's hard to trace back your consumption of a given drug back to any particular manufacturer. So the solution has been, well, what the courts have done is to relax the requirement to show that the manufacturer's activity has caused harm. So what they've instead done is they've ascribed liability, it's called market share liability. So they say, well, look, you've all acted in a negligent way by producing a carcinogenic drug. So you're all sort of culpable in some sense, but we don't know who caused the harm in this particular case. So what we're going to do is we're going to estimate the damage that's caused to you, and we're going to slice it up based on how much of the market share you had at the time. Again, the courts are conceding that, well, look, the statistics about market share, that certainly can't establish a causal effect. But, well, we don't care. We're going to sort of modify evidence law in quite a substantial way to ascribe liability, even without one of these sort of traditional tenets of proof being present. So, and I'm not sure what people think about these cases. I mean, I think that the court's made the right decision in these cases, but what I at least want to sort of motivate is this thought, sort of an interim conclusion, that, well, concerns of fairness cut both ways. So while people who have talked about statistics in the literature often emphasise how it can be unfair to find a defending party liable on the basis of statistics, concerns of fairness actually cut both ways. You can sort of prejudice classes of often sort of very vulnerable pursuing parties by precluding them from relying on statistical evidence. So that sort of blocks the natural thought, well, the reason we don't like statistics is because, well, we need to have a firmer sort of grip on the basis of liability. Having that hardline effect can actually be quite prejudicial to sort of very vulnerable groups in society, I think. And the second view is that, well, excluding bare statistics across the board just by relying on sort of simple epistemic principles is somewhat myopic, because I think, for example, as the asbestos cases show as well, different sorts of types of case raise different issues, and I think we shouldn't decide in advance just because we don't like statistics in some sort of hypothetical cases that this rule should apply across the board. I think that's a sort of short-sighted approach, and I think if that was to become reflected in the law, it would be very damaging. So, I've been trying to think about the sort of features of these cases that make them interesting. So one of them is that they seem to involve what I'm calling sort of epistemic gaps. So you've got a sort of party that causes harm, but yet there's a sort of non-remediable absence of evidence required to prove that they caused that harm. And the second feature is that we need to make a decision about how to apportion a certain burden. So think back to the bus case. One party must suffer a burden. There's a burden that must be apportioned, and there's no way to get around apportioning that burden. Either the person who's been struck by a bus has suffered a harm that they can't be compensated for, or the parties who are implicated in that accident have to be held liable to give them compensation. So there's no getting around this decision about how to apportion that burden. And it's my thought that when we're determining the evidence law that will... So, I should say, we don't apportion this burden on a case-by-case basis. What we do is we decide the sort of tenets of evidence law that will apply to, that will then downstream determine how the burden is apportioned. So it's my thought that when we're working out what these tenets of evidence law should be, that's when we need to think about sort of broader public policy considerations. So the apparent solution the courts have taken is to sort of modify the law to enable holding liable the negligent parties who have benefited from epistemic gaps, at least in the cases we've discussed. So obviously, they needn't do this, right? The alternative solution would be to treat epistemic gap cases like lightning strikes. So of course, if you go out outside, you get sadly struck by lightning, there's no one you can hold liable in that case. And if we didn't find these parties liable in these epistemic gap cases, we would just be treating these asbestos cases as similar to this. We would say, well, it's just like an unfortunate natural fact that's happened that we can't hold anyone responsible for. And you might think this is just not the way to go. It seems like an unprincipled approach. How are we over time? I'm rushing through it. So, zooming out a little bit, I'm trying to think about this in the most schematic terms. So, it's important to be careful about different sorts of case, because the blue bus case isn't like the asbestos case in an important respect. So in the two cases I outlined, the asbestos and the bad drug case, the assumption was that every single party has acted in breach of duty. So all of the employers have acted negligently by exposing their employee to asbestos dust, and all the manufacturers have acted negligently by manufacturing the bad drug. So the negligence of all parties is kind of given, but all we can't do is work out the causal connection between one particular party's negligence and the harm. So the blue bus case is sort of different, right? So this was a case where it's given that there's been an accident, a negligent accident, and there's these two companies. All we know is that one of them has acted negligently, but it's unclear which member of a reference class caused the crime. We're not saying that all the bus companies were negligent, we just know that one of them was, but we don't know which one it was. So there's a sort of bit of a leap from 1 to 2. And just to sort of put the other views on, to sort of map the terrain a little bit, there's obviously, many of you will have heard of the sort of phenomenon of strict liability. So that would be the case where someone's caused non-negligent harm to another. So For example, in making a traffic case where there's been a sort of bump, but you might think, well, it wasn't anyone's fault. There wasn't any sort of negligent mental state there. No one's blameworthy. It was just a sort of unfortunate accident. This is a sort of strict liability. So that it's called strict liability because when legal systems adopt these approaches, the liability is strict in the sense that you don't have to prove negligence. It's just the bare fact that you've caused the harm is enough for you to be on the hook for compensating it. And then there's another case, just to sort of fully flesh out the terrain that no one really discusses, which is, well, proportional strict liability. So you might imagine that one party's caused non-negligent harm, but we don't know which member of a reference class it was. So I'm not sure there's any discussion of the fourth of those. The literature on strict liability is huge, and there's been some stuff about the first two, and that's kind of what I'm interested in. So obviously, thinking about these four cases, you might think, well, look, let's just solve them all. Let's just solve them all in a oneer. And some people do propose this, and this is the solution of, well, let's just have a general no-fault sort of public compensation system. Let's just say, look, when people sort of suffer non-criminal harms when they're going about their daily business, let's just have a general public pot of money to compensate them. There's no need to get into tort law, there's no need to discuss liability and negligence. Let's just compensate people in this way. So, obviously there's a bunch of problems with that. One is that it's sort of resource blind. It doesn't consider the sort of differential economic power of the different participants, who's in a better position to pay than others. Another that it's obviously responsibility blind. I mean, one reason we think we have tort law is because it's actually justified to hold people responsible for harm they negligently cause. If we have this sort of scheme, well, there's no sense of holding people responsible in that way, which you might think is a big loss. The third is it doesn't help us discriminate between sort of different types of harm people might cause. You might think it's a very sort of broad brush approach. You might think we want to discriminate more finely. And fourth, I mean, this isn't a philosophical problem, but fourth, I'm interested in sort of legal reform more generally. Right, and there's an election going on now, so when you go out there and try and propose this policy and see how many votes it wins, it's not going to be a popular policy. People have sort of pursued this for sort of motor car accidents, but it sort of fizzled out decades ago, this project of a general pot for harms. It's a very politically difficult solution. So another way to treat all of these four cases on a par is suggested by just endorsing strict liability across the board. There's no need to care about sort of negligence. And I think France does this for many traffic cases. They've got one of the strictest liability regimes for road traffic accidents in the world, and people are often on the hook just for causing a harm, regardless of whether we think it's negligent or not. So is this plausible? So you might think, so there's a quote from Jeff McMahon talking about why people are liable to defensive harming when they drive. So the idea is that there's a thought that if you're driving along and you lose control of your car and you're not culpable for it in any way, you're not negligent, people are still entitled to harm you to sort of save themselves, as it were. And some of the things he says here you think might apply to civil law as well. So he thinks that what makes a driver liable is that he's voluntarily chosen to set a couple of tons of steel rolling as a means of pursuing his ends, knowing that this would involve a tiny risk that he would lose control of the dangerous object, thereby imperiling the lives of the innocent. And later on in this same paper he talks about, well, what we want in society is to discourage people taking risks for frivolous reasons. So he thinks that all of you frivolous drivers out there are imposing risks on your fellow man and woman, and what we should do is try and sort of discourage this. So you might think that, well, maybe in that case this is a sort of rationale for strict liability. It just stems from the bare fact that you're imposing sort of risks, albeit small risks, on your fellow human. And again, that's quite a radical solution, so I'm not sure I quite buy that, but I just want to map out the sort of possible solutions. What I'm interested in now is to sort of see if we can bridge the sort of asbestos cases to the blue bus cases. So that's the sort of most modest step. We don't need sort of big compensation schemes. We don't need to endorse this sort of wholesale strict liability. I'm kind of interested in whether there's a legal case for moving from the case where all parties have acted in breach, but we don't know who, to holding responsibility parties where only one's acted in breach, but we don't know who. So, let's see. So, again, so our ignorance in the blue bus case concerns who was negligent. It concerns who caused the harm and who was negligent for doing so. So in this, it's unlike the asbestos case. Some very nostalgic buses there. So, one line of thought's this, right? in the asbestos case, we've got no worry about holding all the parties financially responsible, because we've kind of assumed prior that they're all negligent. So that's why we kind of feel like quite happy about holding the employers responsible financially, and that's because we think they've all acted in a sort of negligent way. But in the blue bus case, only one of them has acted negligently. We just don't know who it is. So hence, it would be kind of unfair to treat the non-negligent parties unfairly if we apportion liability based on something like, say, market share. So if you've only got statistics about the three bus companies, the Lib Dem bus company, the Labour bus company, and the Tory bus company, you might think even if we've only got this market share information, we don't want to apportion liability in this case because you'd be guaranteeing treating two of the bus companies in an unfair way. After all, they've not acted negligently. So I think that's a somewhat compelling line of thought, and I want to see if we can sort of push back against this at all. So one reason to think that we might want to rely on statistics, even in cases in which we don't know exactly who's been negligent, the force of this comes from considering sort of monopoly cases. So you might imagine a situation in which a harm has been caused on a given stretch of road, and we know that there's only one bus company sort of in the game, but there are a bunch of like private individuals who own buses. So you might think one bus company owns 99% of the buses on the road, and the other 1% is owned by sort of private individuals. You might think in that case there's a sort of fairly good public policy case they made for, well, assigning liability to the bus company that has the monopoly. And if you think this is right, then this sort of is an alternative to what's been the sort of dominant thought in this blue bus case, which is that the victim should just suffer an uncompensable harm. So the orthodox thought we'd have it where you can't sanction on the basis of statistics. So if there's been an accident of this sort of structure involving any statistical frequency, then the victim should suffer an uncompensable harm. And I'm thinking, well, if you've got cases where there's clearly one dominant economic actor, you might think it's fair enough to apportion liability in those sorts of cases too. Even though we're sort of ignorant about who was responsible, because after all, it could be one of the private bus-owning individuals that caused the harm. So another sort of purpose of tort law is to sort of incentivize and discourage certain sorts of activity. So we want to sort of incentivize safe activity and discourage risky activity, and the way we do this is by imposing economic costs on companies for risky activity and allowing them to escape economic costs by engaging in safe activity. So I think an interesting direction to explore is to think about when can we reasonably hold parties responsible for epistemic gaps. And there's not been that much discussion of this, and I think that this is where the law needs to look to really get a grip on these sorts of cases. So one thought I have is that, well, there might be a sense in which we could hold the companies in these sorts of bus cases as responsible for the epistemic gap. Because you might think there's a very easy sense in which the parties who are contributing to this epistemic gap could have reduced or eliminated the gap. So, for example, GPS sort of tracking equipment is so cheap and so ubiquitous that you might think that you can reasonably hold the parties responsible for not having it, because it's really common knowledge that they might be escaping liability in certain cases because they've sort of chosen not to take a very simple action that would eliminate an epistemic gap. The epistemic gap causes uncompensable harm, and you might think there's a sense in which it's entirely reasonable to suppose economic actors to take steps to eliminate epistemic gaps in this way. So, something I should say, in this sort of bad drug case, the sort of liability we assign is only sort of prima facie, so companies can always bring to court evidence that removes them from the scope of liability. So, for example, if you have 5 companies who manufacture a drug, but one of them has some sort of proof that their drug was safer, or that it couldn't have been their drug that the person took, they're off the hook. So in my case, so all of this just leads to sort of presumption of liability, but it's certainly sort of, you can rebut it. So I'm thinking in this case, in the blue bus case, the sort of similar logic applies, right? The companies can always bring to court evidence that sorts of exculpates them. But I think prima facie it's reasonable to have a sort of presumption that if you can be reasonably held responsible for the existence of an epistemic gap in the law, then I think it's reasonable to sort of attribute liability to you as well. So Another sort of typical criticism of tort law in general, they get sort of bandied around, but I'm not sure how, legal theorists often tend to be somewhat conservative, so I'm not sure to what extent they actually want to reform tort law in this case, but sort of typical criticism is that negligence law is somewhat lucky. So, well, Roman's not here. So, here's some sort of counterfactuals. Imagine someone, a bus driver negligently performs some action with the steering wheel. In World 1, it runs over my sort of crappy 10-pound bike, and in World 2, it dents Roman's Ferrari. So here we've got this sort of, the same negligent action is being performed, but there's a huge asymmetry in the amount of harm caused. So the same negligence is being performed, right? You're still sort of culpable to the exact same extent, but just because of something sort of out with your control, i.e. who happened to be, say, to the right of your vehicle, you're on the hook for either £10 damage or £1 million damage. So this is a sort of typical criticism of tort law. A second counterfactual is this, right? So imagine 3 bus companies have pretty much similar training and hiring practices. That's not that far-fetched. You might imagine for economic reasons that companies tend to sort of have fairly similar policies in this respect. Company A hires a driver on the exact same basis as companies B and C would, and it just so happens that this driver causes a negligent harm. You might think there's a sense in which there's just a sense of sort of arbitrariness here, and it could very much easily be the case that company B or C was on the hook because they might well hire this driver if he just applied for their job instead. So there's all these sorts of cases of luck, and this luck seems to depend on sort of arbitrary features of the sort of the world that maybe the bus company isn't responsible for, even when the sort of negligence is identical. So I think that this might lead to the thought that, well, when companies have similar standards, they're each imposing a sort of similar risk of negligent harm. So you might think, well, if companies A, B, and C have similar hiring and training practices, the sort of risk of negligent harm they're imposing on their fellow humans is exactly the same. And it could very much easily have been the case that, say it was the blue bus company that caused the negligent harm. It could very much easily be the case that it was a driver belonging to the red bus company, if we assume that all of the internal standards are roughly the same. And you might think this sort of supports an argument for sort of extending the liability to all of the parties who have relevantly similar sort of safety standards. Because I guess the complaint was, look, hey, it's unfair to put us all on the hook if only one of us was actually negligent. And my thought as well, if you sort of take a sort of different perspective and think about the role of luck here, there's a sense in which the sort of risk you're all incurring is the same. It could easily be the case that an alternative company imposed the harm. So actually, in that sense, it's not arbitrary to put you all on the hook because you've got similar sorts of standards and the risk is the same. So from that perspective, I think it's actually not so objectionable. So finally, the last part of this project that I don't really thought about much is, well, how do these arguments sort of extend to individuals? They're focused on sort of commercial actors. Because you can imagine purely individual analogues of the blue bus case where you've just got like a sort of country road and there are 2 farmers who use the road and you know the sort of statistical frequency of how often they use it. Would it be fair to make both of them liable in one of these sort of epistemic gappy cases? I think intuitively you're probably more reluctant to accept that sort of thing. The question is, well why? A bunch of sort of explanations might be, well, what about the level of risk they impose? Don't companies impose more risk than others? This might emit sort of counterexamples. You might have sort of, thinking of sort of McMahon's frivolous risks, you might have sort of like compulsive drivers, like individuals who just drive all the time and they thereby impose lots of risk on their fellow human. They're not doing it for any commercial purpose, but they just love to drive, and therefore they're imposing quite a high risk on everyone around them. So you can easily come up with cases where an individual imposes more risk than a company on a given stretch of road. You might think ability to pay is what makes a difference, but of course, imagine Jeff Bezos got into bus driving and sort of drove up and down country roads all the time. He could easily afford to sort of stump up for his sort of negligent action to a much higher extent than any company, so there's sort of counterexamples here. But I think probably that, what the sort of legal theorist in me wants to think is that, well, look, commercial status is often a reasonable rough proxy for both of these things. It's usually the case that commercial actors are better able to pay than private individuals, and almost always the case that they impose sorts of more higher levels of risk than other individuals. And this is the sort of the approach that I imagine the courts would take. They would pick sort of commercial status as a rough proxy and say, well, that's good enough. But it would be nice to have a more sort of robust philosophical underpinning for distinguishing commercial agents from individuals. But often in the law, that's not attainable. And I think it raises sort of broader questions about the sort of distributive justice principles we use in tort law. So, I mean, I think the sort of cases I presented today kind of make us might think it's a sort of maximin sort of distribution. We're sort of looking at the people who are most susceptible to uncompensable harms, and we're trying to improve their situation with respect to risk at the expense of people who are better able to bear, better able to sort of take liability for the crimes. But I think there's a lot of interesting work in legal theory needs to be done in sort of working out exactly the structure of these principles and how they apply. As I said, this is very much work in progress, so hopefully you can help me out with some of these questions. Thank you very much for listening.